All right, Lyric Armstrong here, your real estate agent and advocate. We are here. We are at Judge Middleton's court. He is back from vacation and his court is on a roll. We have great little gems of so catch up, catch up. I did a video earlier that had a great piece of information about getting a lien upon your property when you go in and sign up with your different contractors, your neighborhood salesmen. So buyer beware and how that affects your real estate. And now we have a great case. This is a land contract case. So purchasing real estate can be done in various ways. And it's a beautiful thing to exercise, to go ahead and purchase the real estate in the way that you can, whether you get a loan for it or you do a seller carryback, or in this particular instance, you do a land sales contract, or you do a rent with option to buy. Whatever gets you to the successful place of owning real estate and building your generational wealth. That's what you go for. What's best for you. Now, this particular element is always, we're in a place we want to learn. We want to learn from others. And this is a great place to learn because this kind of combines a lot of the concerns we've been talking about lately when it comes to dying and not having a will, or dying and not having a trust. So you go through probate, or you have these particular instances. How does it affect your property? This particular litigant, I'm sorry, the deceased was a party in the contract. They are now deceased. The contract has not been fulfilled. And so what is going to happen with the property? Judge Middleton is going to show us and tell us a lot of great information so that you can be aware of what your rights would be. This is really relative to Michigan's law. So obviously you need to research the particulars for your particular state. However, a lot of times the concepts carry over. It's just sometimes the days and the amounts and the percentages and those particular particulars, the specifics of the concepts may be different from state to state, but conceptually they're usually around the same concept and theory as to how the law would apply. So let's learn and find out. Don't forget to like, share, and subscribe. Judge Middleton, we're ready for court. Take us away. We want to hear all. Oh, that's not the right court. This is Zoom court. We don't want to go to Zoom court. Well, we do, but we want to go Judge Middleton's court. All right, come on, Judge Middleton. Tell us all about it.
All right, who?
This lady
Cassandra.
is not
Just try to
fast forward through her. Okay.
Okay, then let me call this case. This is file 23835 SP. It's entitled Odessa Miller versus, so let me look at the actual headline. A lot of parties here. Mary Bell Spence and others. This is continuing possession after land contract forfeiture. Mr. John Bush is here for the plaintiff, and here is Deb Miller Stack. All right, I've got several people here. Good afternoon. This is Judge Middleton. You're a little early, which is fine. Who am I speaking with? I got Deb Miller Stack. Who else is present?
Rocky Miller.
Odessa Miller. I'm the Deb.
Okay. That's 3 of the 4 plaintiffs. All right. All right, this is a land contract, which is substantially delinquent. Less than 50% of the purchase price has been paid. Mr. Slowinski was here last week and was helpful. He gave us some background information, but didn't actually have any standing and didn't have a license to practice law, but it was helpful to have him here.
Okay. Standing means he's not a party in the case. So he's not a party in the case and he doesn't have a license to practice law, so he cannot represent a party in the case. And Mr. Slowinski is the gentleman that is with the young lady here to the left. So he gave some factual understanding. He gave background to the court, but truthfully, the court cannot consider it, is basically what he's saying, just because of those particular issues.
Mr. Bush, what's the current status here?
You're right. To the best of my knowledge, nothing's changed. The land contract is still.
Bush is on site. He is the attorney for Deb Miller Stack Incorporation here, whatever their names are as a corporation.
In the fall, I've not been presenting any letters of authority or any estate that's been opened on behalf of Mary Bell Spence.
He said he did not get any letters of authority on behalf of Mary Bell Spence. And the Mary Bell Spence is the deceased party. She was in contract originally with Deb Miller Stack Corporation and for the land sales contract. So what does that mean? That means you have to open up the estate. That means you need a probate estate attorney so that they can open up the estate and perform special acts on behalf of the deceased, which would be the letters of authority that would go to Deb Miller or her attorney, letting them know that the estate wants to pursue the contract and fulfill the terms of the contract.
Ms. Spence, what's your position?
I've been making the house payments regularly every month, $800 each month. I've been making sure it's been sent to Odessa Miller like I was asked.
That's interesting. I heard it, but I didn't ping into the fact that she said, like I was asked. Who asked you to do that? That's a good, I would want to know that, but I don't think it gets cleared up. We'll see.
I've been living here since before my mom.
Because then I would argue if Deborah Miller and her corporation said, you send me the payments, then I would say, well, we're in contract with one another. When they need to amend the contract and add us to it.
I passed away.
But maybe it wasn't her. Maybe it was the mom said, make sure you send the payments to Debbie.
What's your full name?
Genevieve Maurice Spence.
Lowell Spence? Or was he Mary Bell's husband? Mr. Slawinski gave us.
Okay, I'm kind of moving past this just because this is not pertinent to have everybody's name. Sometimes it's good to like not know everybody, but just for the World Wide Web, of course, the court needs to know. He's just verifying that she lived there, that her daughter lives there, her brother lives there. Who are the individuals who live? Oh, and her dad. They all live in this house. And the dad is the ex-husband of Mary Bell Spence, not the current husband. So that becomes a question that gets cleared up, because if he was the husband, then it's, well, maybe the contract can go straight to him. But
some of this last week, but I'm trying to pin it down. Who else is there?
My 17-year-old daughter, Elizabeth Smith, and
Slow down.
Did you say Andy?
Andy Spence. All right, this contract was with Mary Bell Spence, and she is deceased. And so, as Mr. Bush indicated, no one has started an estate to deal with the effects of Mary Bell Spence. They have been continuing to accept your payments, which is, I guess, relevant, but the contract is not in anybody's name who's living there, and it is substantially delinquent. Mr. Bush, how much is due and owing at this point?
I may be off a couple of months if there have been payments, but I would go back to our complaint on June 5th. We showed $57,323.59. That may be somewhat less if she's made, we'd have to do calculations if it made the payments in June and July.
Do you have a judgment with you?
I don't believe I do. I will submit one when we have the numbers.
Well, in a land contract, it's different than a lease. If you've paid more than 50% of the purchase price, you have 180 days to redeem it. If you've paid less than the purchase price, 50% of the purchase price, you have 90 days to redeem it. The problem is this contract is in the name of Mary Bell Spence. It's not in the name of Genevieve Spence or anybody else that's actually living there. They could come up with a new contract, but at this point, and Mary Bell Spence presently has no legal standing. The estate of Mary Bell Spence could have some lawful standing. But what is Ms. Miller Stack, or someone, can you tell me what the current arrearage is?
I'm sorry, I cannot. I don't have the amortization table filled out at this time. We'd have to pursue that to find out for sure.
Well, she says she's been making the payments. This thing was paid in June. Did you get a May payment, June payment, July payment?
We received, yes, the May, June, July.
All right, so she's right. She's been making her payments each month. What you folks need to do is sit down, perhaps with the assistance of Mr. Bush, figure out what you want to do. One option would be to execute a new land contract with the people that are actually there. But they have 90 days to pay this. But this is similar to, all right, let's say that my brother I don't have a brother, agreed to buy a house for $90,000. He was paying the land contract and he died. And I didn't do an estate. Even if I paid for the contract, paid the whole price, I wouldn't own the house because I'm not on the contract. So there needs to be some further legal activity to get this where it needs to be. They could forfeit the land contract and in 90 days kick you guys all out on the street. Maybe that's what they want. But then they could sell the house, or you could pay the amount and perhaps they would give you a quitclaim deed to the house. But there's a missing step that none of you are actually on the lease.
So you got the contract.
Or on the contract. I'm just going to use Mr. Bush's numbers. Through June, the arrearage is 57,320, 359. That's as of April, although you've continued to make the payment. So let's use the April date that's on your complaint.
Okay.
Because you actually owe less than that. And so they're certainly willing to continue to accept your payments, but the contract, I think, had a balloon date and the entire amount is due.
Okay, so real quick for those of us who survived the 2008 housing crisis, a lot of it stemmed from balloon payments. Okay, so balloon payments are these payments that come either in between date, they can come at any time actually. The way they were structured some time ago is they would come like 60, 90 days after the first payment. You might have to pay $10,000 and then your next 3 payments go up a little bit. It just depends on what the payment schedules are. So this particular instance, there was a balloon payment due on this particular contract where it calls for the whole payment, which is the $50-something thousand was supposed to be paid. And the defendant has been continuously making the monthly payments of the $800, but obviously the $800 has not satisfied the full $50,000+ owed. And so the balloon payment just means a big chunk is, a big balloon or a big chunk of payment is due, depending on which amount is given. And on this contract, it's saying at this particular juncture within the contract, the balloon payment is the whole payment. It's the whole amount owed. And some of the other legalese that came through was the judge was talking about the statutory law that requires for Michigan that if you're entered into a land contract, you have to have paid 50% of the land, the sales amount, in order to get 180 days to pay off the other 50% and claim your deed, in essence. And if you've paid, I think 25% is what he said, or less than the 50% at least, then you would have only 90 days to pay off the balance. So that's what gives you the time tickler, is relative to how much you have paid already. But relative to this contract, it's asking for the full balloon payment. So the judge is put in a position where they would have 190 days to make no, because they paid less than the 50%. So they would have 90 days to pay the full balloon payment, the 50-some-odd thousand, whatever that comes out to be once they've calculated the months that are necessary. But it wouldn't cure anything, because actually they don't have the ability to make the purchase because they're not in contract for the purchase. They have not opened an estate on behalf of their deceased loved one. And so there are no letters of authority authorization. So they cannot actually claim it. They really need to go into a negotiating position with the owners and their attorney, maybe get their own attorney, and sit down at the table and negotiate a few things, maybe get an amendment to the contract that adds them so they can get all the credit that was yielded by their mom, or go into a whole new contract and see, if they can negotiate for the same amount that's owed. Because actually, if they go into a new contract, they don't have to take into credit for what their mom has paid. towards the new contract, and they can go and sell this property all over again. And they could say, no, we don't want to go into contract with you at all, and put it on the open market and sell it for even double than what, you know, they were going to sell it for their mom, depending on what the contract calls for and what the marketplace is for that area. So a lot of things can happen. So when you don't have a will and you don't have a trust, and I don't know why she's the only name on the land sales contract, you know, put your name and trust, put it, you know, you can enter a contract. You can buy a house in the trust. So you can have a trust and buy a house in the name of the trust. So the beneficiaries can be laid out in that trust, and therefore the contract will flow with the trust. And you don't have to go through this process. But when you don't have things aligned and you haven't let professionals do professional things, we are in litigation. Litigation costs time, litigation costs money, and quite honestly, the plaintiffs may take issue with just, you know, starting off with the $50-some-odd thousand because they had to pay an attorney to come to fight this issue in the first place, right? So get a trust, a wills and a trust. I'm telling you, a wills and a trust. Get yourself an attorney. If you have any financials, anything that you want to pass on to your kids or your loved ones, or to the church, or to the orphanage, or to the nonprofits, wherever you want it to go, get a will and a trust so you can avoid court. This is a situation where the deceased failed to do that, and now the kids are in a place where maybe they will or will not be able to purchase this property. It's unfortunate. So learn from the mistakes being made. This is learning, not judgment. Let's learn.
All right, Mr. Bush is going to submit an order, which I'm going to sign. You could really use some legal help, and perhaps all of you could discuss this and see if you can come up with perhaps a new land contract. But if you wish to foreclose this one, they have 90 days from today.
Excuse me, do you have a judgment, or do I need to?
I don't have one.
I will probably get one.
I have a complaint, I have a
That
notice,
to
but I
me
do not
is-
have a
All
judgment.
right, we will get that.
That to me is still a confusing issue, because the judge is saying they'll have 90 days from today to make the full purchase. But even if they made the full purchase, it's not going to go in their name. You know, they would, I guess maybe just having a simple addendum, and just have that addendum say to put it in the name of the trust, or put it in the name of all of these individuals, or put it in the name of the one person. That may cure that issue, but they would definitely have to address how they would vest the property, because otherwise they would be vesting the property in a woman who is deceased name.
I don't want to make a liar out of myself. Let me look again, but I didn't see one.
We usually submit it, but it's very possible that.
So I have two questions, if I could ask.
Yes,
The first one is this: the forfeiture notice says that the land contract all due and payable on October 1st of 2016. Ray Miller passed away in 2021, if I remember right. But in 2020, when I talked with him, he told me nothing was past due. That's why we continued making the payments, because I had asked him at that time if there was back pay or back things that needed to be paid off.
well, the contract speaks for itself over and above any oral representations. You could greatly benefit from some legal help.
That leads me to the second question. Genevieve here has attempted to call the number that the young lady gave me from there. They waited a week and said that until there's an order that says that they're being evicted, they can't be helped.
Well, they have 90 days.
So as of tomorrow, they can call them and tell them that they're being evicted.
Well, they aren't being evicted yet, but they have a land contract clock ticking of 90 days. Yes, they should be able to. Now, normally our legal aid person is here, but she's not here today. They often don't get involved in land contracts. They're more involved normally in leases, but 90 days from today would be 30 days, 31 days in August, 30 days in September. Would be 61, October 29th. Yes, they will get, now it'll take a couple of days. Mr. Bush is going to email it to us. I will sign it and we'll send it to them. As for the plaintiffs, Mr. Miller and Ms. Stack, and the other Mrs. Miller, you may decide what you wish to do, whether you wish to get this house back and have to get them out and get somebody else in, or try to negotiate some sort of new land contract. All right, the arrearage is 57, 323, 55. through April. Defendant should have credit for May, June, and July.
I would specifically put that in the document.
All right. This case needs some more work. All right. I will send you that. You guys certainly could use some help. All right. Thank you.
Thank you, Judge. Thank you.
Thank you.
Thank you, Judge.
So are we
Thank you.
getting
Yes.
something that's gonna help
Yes,
us?
you'll get it in the mail within the next couple of days.
Okay, just so I understand where they're at, because they're gonna call me when they get it then.
All right. Thank you.
Okay, I leave.
Okay, so what a interesting piece of educational legislation right there, litigation, I should say. Judge Middleton has done a great job at showing us where having a trust is important, and also utilizing the services of our professional attorneys is highly recommended, because they are in a position where they just might lose the credit and the house and the standing just because they don't have legal standing as individuals. And the way that the contract was set up, it was set up individual to corporation, sounds like, or individual to multi-party versus trust. So because it wasn't put in a trust and estates has not been opened up in the decedent's name, not sure what's going on, maybe a financial situation that's preventing them from having an attorney open up an estate, but it's not doing them any favors, because depending on what the landlord wants to do, the seller wants to do, they might start over with someone altogether different and do a contract with someone different, or they might just sell it outright to someone else. And the tenant slash buyer would not be getting their money back, in essence, or their mom's money back. They don't get that back. And so it's a hard lesson to learn, but now that we've learned it, we can do better for ourselves, and we are grateful that we were able to learn from these litigants something that happens when we're gone, when we're dead. We're not going to be here to know, so it's good to find out what happens when we're gone. So consequently, we have learned that we will use our attorneys, and we will get a trust and have a wills and a trust, and have all things of value in the will and trust, because that's another thing that happens. People will get a trust and then they go off and they buy another property and they don't add it to the trust. You have to make sure that all of the valuable things are in the trust so that it's covered by the trust. Otherwise, if there's something dangling on the outside of the trust, that thing will go to probate. Okay, so we want to avoid probate, right? Probate does nothing but take the asset and diminish it because you have to fight to keep it and to upkeep it and go to court and spend all the money to do it. So we want to avoid probate as much as possible. All right, I hope you've learned something. So like, share, and subscribe. Let someone else learn. This is important stuff. Things we learn now can help us later, and this is the benefit for building generational wealth and understanding that these are the outcomes that come about when we're long gone and buried in our graves. So we want to know what steps to take now so that when we're gone, our children and our beneficiaries are not suffering in the same scenario as these litigants may be. All right. Have a good one. Lyric Armstrong, your real estate agent advocate. Like, share, and subscribe.